And so, since the parties have filed their respective heads of argument, once you get the bandwidth and you are afforded an opportunity to go through the papers, then it is only then that the matter can be said to be ripe for argument.
Yes.
On a last shot, I'm done with that aspect, your Lordship. There's this other thing, the Lordship. As I believe you've noted, Lordship, we've raised the issue of disputes of fact. Which are irresolvable on affidavit. And a perusal of the applicant's affidavits, in the plural affidavits, both the founding and the replying affidavits, they do not deal with those issues. And we do not want to be ambushed. For now, all we can do, Your Lordship, is to request a postponement of the matter so that we can deal with the issues properly, and that the applicant indicates if our intended application for referral of those issues as indicated in our brief. For now,
1 year.
Yes. May I say the application, the referral of the matter to oral evidence up until the crime is indicated. We don't want to be ambushed with respect, because and we also don't want to be objecting when they raise those issues from the back. When we've
So now just wait, counsel. You're saying for now will not be applying that the matter be referred to oral evidence.
I can, if the court does allow me.
Now I'm asking you from what you have just said.
Okay, may I move the application, Your Lordship, that the matter be referred to oral evidence, because there are two ways of resolving disputes of fact. It's either the matter is referred to trial or to oral evidence on specified issues. We have specified the issues which we request that they be referred to oral evidence. His Lordship will notice that all the issues raised in our heads of argument are key to the extradition issue. His Lordship will note that there is an issue, particularly of threat to life to the respondents, and the allegations, serious allegations made against against the South African authorities, let me just put it in that way, and collusion with the police. So we need to argue that point with respect to your lordship, and or rather, if his lordship looks at the replying affidavit, we made these arguments in our answering papers, and in their answering affidavit, they have not addressed in their affidavit, they have not addressed that issue. They are just getting around it. All the issues in our heads of argument are raised in our answering affidavits, Your Lordship. So Your Lordship, as I'm summing up, His Lordship would notice that in their replying affidavit, they are just getting around the issue. They are only making reference to two case numbers that they've got evidence to the effect, but there is no denial of the allegations made by the applicants, by the respondents. I'm sorry. And those cases, as I've already indicated, only alleges that they've got evidence to the effect, and then this case numbers. Which is a bare allegation. Okay.
So now, Mr. Marina, yes, Mr. Marina, they raised concerns and requests.
It's what I wanted to get into.
Yes, through a correspondence to say they have a difficulty in addressing that in terms of denying, especially because no sufficient averments were made around that issue. Now, they said it was not specified as to which are these police officers who were colluding with the other faction and making the threats.
Precisely, Your Lordship. Hence, we require oral evidence to the effect. We also have our own witnesses.
So now, Counsel, why was it why could you not perhaps file a supplementary affidavit to add flesh on that? Because now with application proceedings, especially where affidavits are relied upon, now you have the principle of he who Now you have the principle of he who, in fact, a litigant stands or fall by his affidavit, meaning that you have to say it all or make sufficient averments in the affidavit. Two responses I can give to the court. For one, they do not have access, both respondents do not have access to telephone calls outside of the country. Yes, but now, now in as much as they are incarcerated, now they are represented by counsels to whom they are giving instructions, including information relied upon in drafting the affidavits. Now they are the ones who who are supposed to know as to which are these police officers, from which police station,
in any event, with respect to Lordship, it would mean that those people, even if the respondents can indicate them to us, can come to a sorting. And it's a tedious exercise. And some of them, they are alleged co-perpetrators and or accused are in prison. Now we're going to get hold of
no, just wait. Now, what the concerns of the applicants was that they do not even know through the affidavits, files, or averments made as to which are these police officers who made these threats, from which police station. There's nothing appearing for them to then deny. With
respect, Your Lordship, it's not what I've read in their replying affidavits, unless you've got different ones.
No, that is what that was written to you. Same also appears in the replying affidavit.
No, with respect, Your Lordship, it's not there in the replying affidavit. And we cannot be litigating via correspondence because we're dealing with papers.
Now, in the replying affidavit, we now have you gone through the replying affidavit?
In any event, without belaboring the court, I've just missed the other point which I wanted to highlight to the court.
Yes, Mr. McGee.
I'm sorry, Your Lordship. Yes, Your Lordship. So like I have indicated, the hindrance of communication, because they are the ones who should contact their relatives to deal with this issue. And there is one last issue which has just slipped my mind.
Now what page? Now Mr. Numalo, I can see you have opened the page in the replying affidavit. What page is that?
Yes, Your Lordship. It's paragraph 37 of the second additional affidavit, Your Lordship. From the attached to the replying affidavit.
Lordship, as I've indicated, that all they're dealing with, the applicant deals with, is correspondence. Let us look at the affidavit, statements under oath. Because, oh yeah, that's the last point I almost forgot. That we even with respect.
Seemingly he's lost. He must look at the replying affidavit so that he can properly address the court.
If you can show me where in paragraph 37 of the affidavit the allegations he's making are valid. Yeah, it's just an attachment. These are serious allegations, Your Lordship. In any event, Your Lordship, in any event,
may I
I'm sorry.
Because he is misleading the court. This is not an attachment, it's a replying affidavit. You must look at paragraph 8C, paragraph 41. It is condemned in a replying affidavit. It's not an attachment. That's why I say he must put his house in order first before he misleads the court.
Yes, that is why I was trying to give guidance to counsel.
We are talking, Your Lordship, with respect, we are talking about an replying affidavit which has been filed before court. There's not even paragraph 41 in that affidavit. Your Lordship, just to wind up on that issue, this court, well, I'm requesting in this court that it takes into account that one should not be oblivious to the fact that despite even a request to have statements from the witnesses with their identities removed. So the long and short of it, our application, Your Lordship, is for a postponement of the matter due to the reasons we've cited, and further referring the matter to oral evidence on the specified issues as they appear in our heads of agreement. That will be all.
Yes, if there was something like that, I would give them to check the country with you would say about that I would say toilet packet fast, okay? I know what they back to me about the about how I'm sitting there, but that I would do me and I hope I
Firstly, Your Lordship, may I deal with the issue of the book of meetings that was served upon the respondent this morning? But Your Lordship, a book of pleading contains all the papers that is in exchange between the parties.
Le ncwadi leyo ifaka onke lemaphepha lebandikiselene wona-ke yakhona.
Yes.
In the present matter, Your Lordship, the set of documents contained in the book of pleading is the application, Your Lordship, by the applicants. And the second, Your Lordship, is an answering affidavit from the respondent.
Yes.
And the third, Your Lordship, is a reply by the applicant, Your Lordship. All this set of documents, Your Lordship, are in possession of the respondent.
So onke ke lamaphepha lakhona ke kule ncwadi labaniketwe yona ngilamaphepha lakhona ke kubo nalabengaqhamuka kubo nalabengaqhamuka kubo ke baso.
It is surprising, therefore, Your Lordship, that a matter of this magnitude can be postponed just because the other party is alleging that he has not perused the book of pleadings.
Kuyamangalisa ukuthi ke lenza bana sengathethesela phambili nesizathu sokuthi ukuthi ke lo munye ke akabengakakhoni ke ukuthi ke angabuka ke le ncwadi lena esekaniketwa yona.
Unless Your Lordship, he alleges that there are new documents inserted in the book of pleadings, he or she is not in possession of.
Ngaphandle nangabe athi kukhona ke lamanye ke maphepha lamasha ke lathi uphi wona bese ayafakwa lapha ke kule ncwadi.
In our view, Your Lordship, this is just a strategy to cure the lack of preparedness on the part of the respondent, Your Lordship, to deal with this matter on this day. We are therefore opposed to the application for postponement on the basis of the issue of the book of pleadings.
Sike bayaphikisana ngena ukuthi lenzayo ngathi kusela phambili ke nesizathu salo ukuthi nje kufakwe lena ncwadi.
Yes.
The second issue, Lordship, is in respect of the heads of argument.
Yes.
It is fortunate, Your Lordship, that the court, this honorable court, has picked up that the applicants, the respondents, are not dealing with the contents of the extradition at all. They've just submitted a skeleton, Lordship. Say the least.
Bonile kusika kaphendulike lokufuna ke bakuphendule bona nje baletheke ubumi.
As there is no relevance to the issue at hand.
Akuhambisani ke nalokho okukhulunywa.
Yes.
On the application for oral evidence, Lordship, there is no substance in that application, Lordship, at all. On the basis that there is no dispute of fact that arises in this proceedings. paragraph 5 of the scanty head, Your Lordship. They say the applicants do not dispute that there is a threat.
Yes.
That issue is taken care of, Your Lordship. We have, the applicant has put categorically in the affidavit, in its affidavit, that issue is being attended to, Your Lordship. And we listed the institutions, Your Lordship, that will attend to that issue. The question remains, is that is there any a dispute of fact arising in that issue? Actually not, there is none. Yes, the question is, what will the person that will be called to come and testify say more than what is contained in the paper? Actually, nothing.
Yes.
Your Lordship, the other aspect is the issue of alibi, Your Lordship, that they have raised, Your Lordship. The issue of alibi, meaning that they were not at the scene of the commission, or at the date of the commission of the crime. Your Lordship, based on that, Your Lordship, we wrote them a letter, Your Lordship. We served them with a letter on the 9th of July, Your Lordship, requesting certain particulars, Your Lordship. Just ignored it. We requested a specific information, Your Lordship. Yes, Your Lordship, paragraph 3.1 of the letter, Your Lordship, it's in respect of I Ndimande's answering affidavit, Your Lordship. We say we requested the details of the policemen that are alleged to have met threats as per paragraph 11 of their answering affidavit, their answering affidavit, Your Lordship. And, oh yes.
noma-ke imininingwane yaleli phoyisa leli bekase imisabisa.
In respect of Manus Ndimande is answering affidavit 3.2, Your Lordship, the name and location of the state hospital that they alleged he was being treated, Your Lordship, at the time of the commission of the offense.
Ngakumantu sindimande ke khona kuthiwa ke kucelwe ke igama ke laleso sibhedlela ke lebeka kathi ke elashwa kwiso.
We also requested for the name and from the state hospital.
Bacele ke ilanga ke la ngalo ke nelanga la kaphuma ngalo ke esibhedlela.
We further requested the details of the boarding school, including the name and the location thereof, Your Lordship.
Baphinde futhi ke bacela ke neligama ke lalesikolo lapho beka khona ukuthi indzawo.
This was an attempt to comply with the principle of alibi, Your Lordship.
Lokho ke bekuyindlela yokuthi ke bazame ukuthi ke bakhone ukuconza ukuthi ke bengangena kwendele khona ngecala.
In terms, it is tried law, Your Lordship, that if an accused alleges that an alibi, he must bring notice to the prosecution, Your Lordship. In fact, in this matter, Your Lordship, they indicated in the answering affidavit, Your Lordship. And the applicant was duty bound to investigate those allegations, Your Lordship.
Yes.
But the applicant could not conduct the investigation due to the fact that the accused, the respondent just made a bare allegation without any evidence, Lordship, to that effect. The requirement is that the respondent is the address where he was. The prosecution investigate that such circumstances, Your Lordship.